Hello everybody, it's Rick. It is Saturday, July 1st, 2017. If you need to contact me for a donation to receive affidavits for child support, to fight child support, I have approximately 45 and a lot of PDFs, about 50 PDFs related to, to child support and an array of other laws. And trust me, you're going to have a lot to read. You're going to learn a lot. And it's the email is rick0327@me.com. I get a lot of emails, and my thing is child support. Okay, I'm not a custody guy, although I've helped a couple of people. I believe that if you fight by implementing your guarantees in the Constitution, it's hard to lose. Now, it's not going to be easy, of course, because we're dealing courts. Although they're supposed to follow the Constitution, if it was just that easy to walk into a court and go, well, the First Amendment gives me a right to privacy. The Fifth Amendment guarantees me due process. The Fourth Amendment guarantees that you cannot take my property unless by a warrant. Well, we know that our child support is being taken by these income withholding orders that aren't signed by a judge. They're not issued by a court. And yet, when we go to court, we get a hard time to fight this stuff. So, it's not that easy. Okay? And I'm not the only one doing this. There's other people out there fighting the good fight. Okay? Amen Osiris, AMEN-OSIRIS. Myself, of course. If you want to learn how to speak in court, how to properly object, and how to represent yourself in the court, okay, this guy, I didn't know he was a fan of mine, because I was a fan of his first, because his channel was before mine. His name is Joe. It's Joe from Hawaii. He used to have a channel called Cop Watch Hawaii, and he has this channel now called Ethical Anarchism Advocacy. Joe, I hope I got that right. And you go on his channel, and he'll teach you how to avoid the pitfalls of these judges, what they try and do to you. And it's these judges that try and trip you up all the time. Okay, they don't answer questions. It's a whole bunch of stuff. He's really good at it. And I have to correct the mistake I made in the last video. I said substantive rights. I meant substantive. Now, if you would have punched in substantive rights, it would have corrected it and say, do you mean substantive rights? Did this guy Rick on his channel, who's always mispronouncing words, at least one time a video he's mispronouncing something? Yes, it's substantive. I had the meaning right, but I had the word wrong. Okay, now you got substantive due process, which is a constitutional law, is a principle allowing courts to protect certain rights deemed fundamental. Okay, to protect certain rights deemed fundamental from governmental interference. Doesn't that sound simple? But it's one of the harder things that get done in the court. You're not going to get that done in a kangaroo tribunal called the family court. And I call it family court. In New York State, it's called family court. The process is family law, child support. Okay, so if you hear me say that, whatever it is in your area, I know they have it in certain circuit courts, superior courts, courts of common pleas. It's child support, okay? It's a tribunal, it's a kangaroo court. Okay? But you have to do it at this level. You have to bring up your substantive rights. You have to bring it up. Because if you don't bring it up, you can't appeal it later on. That's the way it works. So you have to bring up your jurisdiction. Where is this court getting its jurisdiction from? Or as Joe would say, from Hawaii. Okay? Could you please clarify? Objection. Clarification of jurisdiction. Clarification of evidence. See, we discussed it in a prior video where, and I'm going to do a video on it on my computer, so just bear with me. I was talking about the injury in fact caused by you, if you're the respondent. Okay? And the likelihood that the court has the ability to succeed. Now see, here's the way it works. You bring a petition. You're supposed to bring evidence of an injury. Then you got to tie that injury to the respondent. Then they got to weigh everything, and the court has to look at it and look at the likelihood they're able to redress and remedy it. So it's a three-pronged approach. Okay, as stated by the Supreme Court. Okay, it's a long case. Lujan versus Defenders of Wildlife. It's a 1992 case. Justice Scalia was involved. You know, one of the greatest Supreme Court justices who died mysteriously last year. Okay, and it's a very key Supreme Court case for us, because when we're brought in for child support, is anybody ever talking about an injury in fact? Well, here's the injury in fact. Now, oh, by the way, I gotta stay on topic. By the way, the injury in fact is presumed by the family court agency that's represent. I love when they have them as the petitioner. That's my favorite. They're claiming that the mother, the custodial parent, is on welfare because of non-payment by you. Now, is that an injury? I don't think that's an injury. I discussed that in my prior video. So how are they going to be able to argue and present an injury? So if we stay on that, like let's think about the last couple of weeks. We discovered that a non-judicial person, quorum non-judice, cannot issue a support order. How many of you out there have support orders issued by one of these people? You know, these commissioners, support magistrates, all of these pretend judges, as we call them, fake judges, right? They're non-judicial people or persons, right? Now we got that, right? Then we have our 7th Amendment right. Remember, that's a substantive right. Is your right to a trial by jury of your peers. Okay? So, in any controversy of $20 or more. Now, the $20 or more controversy has to be proven that you caused somebody that you owe them more than $20. So we need that. So, is there an order entered against you by a judge who's playing the jury at the same time? It's called a bench trial or a summary judgment. These things are mostly summary judgments. Okay? But where's the evidence? How many of you could look at that support order and find, oh, okay, Exhibit A. Exhibit A, blah, 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 mark. Does anybody ever see that? No. So how are they going to claim that that there's evidence against you showing an injury in fact? Now we start to see how this is all a big show. It's a big production. All rise. Raise your right hand. Your Honor. Meanwhile, Your Honor's a non-judicial person. Supreme Court says, Burnham versus Superior Court, that a non-judicial person any order is void. Okay? Why? Because there was no judicial person in the room. Now, then sometimes you'll get an order issued by a non-judicial person and then signed by a judge who was not there. Is that valid? No. That's hearsay. The judge was not there. The judge is basing everything on evidence gathered, if there's any evidence, by the non-judicial person. They do that in New York. It doesn't happen too often, but that's the way it's supposed to work. Because in New York, the support magistrate issues an order, and it's supposed to be signed by a judge, or it lacks legal force. It says it right in Family Court Act 439, which is proof that you need a judicial signature, because they're telling you right there in that Family Court Act 439, they're telling you right there that without a judicial confirmation, it lacks legal force. Okay? So we know we're on the right track. We have a bunch of remedies. It's our job to put it all together. It is a matrix. You know, I did a video on that a while ago. And I'm going to show you another side of the matrix. Now, the Secretary of Health and Human Services, they're supposed to determine the debt on an income withholding order. And the income withholding order is supposed to be issued by the Secretary of Health and Human Services under 45 CFR 32, Part 32. So now if you go after the Child Support Agency, the Department of Health and Human Services, because they're the ones, remember, if they're the petitioner, let's say, whatever county, Indiana, Child Support Services, petitioner, John Doe, respondent, owes child support. You owe child support. Okay, but where's the debt? Where's the proof of the debt? Because technically, they're supposed to have gathered a proof of the debt, presented to the Secretary of Health and Human Services, then he makes a determination and issues an income withholding order. That's the way it's supposed to work. But back then, I wasn't sharing it because I didn't want to share it with other channels. Okay? You know, I got a couple of, smart-ass channels out there. Well, really one. The other guy, I don't have a problem with. We made peace. Another guy, I can't mention his name because he gets 35, 40 views. So I don't want that to go any higher. Okay? And it all started because he has no manners. See, the guys those dislikes that you see in my videos, there's always 2 or 3 of them. That arises from people who are rude. That's all it's from. It's the same people. They come in the comment section and they're rude. Know it all. Now, I made that mistake in the last video. The Substantive. And Joe from Hawaii pointed it out. Now, Joe runs his own channel, so Joe knows this. Just like, I'm in Osiris. If I made a mistake, he would correct it, but in a nice way. There's a way of going about it. You don't try and show somebody up, okay? I don't go to other channels and in the comments section and go, oh, you're wrong, blah, 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 blah. I don't do that. You could do it in a different way. You're polite. There's no reason to show anybody up. Doesn't mean that you're smarter than me if I made a mistake. We all make mistakes. There's no expert here. So Joe's like, give me substantive, thank you, Joe, and I fixed it. But this other guy one time, he's like, didn't I tell you you got to do it this? I swear to God, I was like, didn't I tell you you got? I was like, who the fuck is this guy? You know, and I seen him in the comment section. You know, he was. I let it go. I was like, you know, there's a know-it-all. You remember I told you the Captain Obvious know-it-all? You got some guys, what they do, I told you, they watch a lot of videos. They spend a lot of time on YouTube, and they're, you know, they become experts from watching videos. Listen, if you spend a lot of time on YouTube, you learn a lot of stuff. There's a lot of information on YouTube. I learned, thank God for YouTube. I thank every day for YouTube. I would not be where I am right now if it's not for YouTube. But it doesn't make me an expert. I'm always learning. And I didn't get to know what I know about child support because of YouTube. I learned this on my own. And of course I did my research, but I learned a lot of it from trial and error, from a lot of reading, from a lot of typing, from a lot of stress, okay? Over 20 times going to hearings in family court. I can't tell you how many filings I made, okay? A lot of trial and error. I know what to write now because I know how they respond. So, like, you know, if somebody writes stuff and they start going, and they committed fraud, like, you write in such a way, listen, you could beat them using their own words, using their own rules. Let's not start accusing them of crimes and stuff, because then they're going to get really defensive. You know what I'm saying? We could beat them without doing that. Hey, and I used to do that, so listen, I know. Hey, in my paperwork, I was threatening to arrest a support magistrate. I wasn't too smart, but that's how confident I was at that time. And I was testing them out. And then when I went to court the next time, there was at least 12 guys wearing leather gloves in that room. At least 12. I was surrounded. And all of those dummies were standing there protecting that woman who was committing crimes against me. And in that hearing, I was like, I need to see your oath of office. And she wouldn't give it to me. So I'm like, you're refusing to give me the oath of office? And she was ignoring me. And I'm like, why are all these guys in here wearing leather gloves? So I got up and left. I'm like, I don't feel safe here. I'm leaving. And I left. You know, one guy was wearing gloves. Like, what are you going to do with those gloves? Are you kidding me? So, you know, because of that, you know, they issued a be on the lookout report. Every time I would go there, they'd follow me around, but they don't do that anymore. But anyway, getting back to what I was saying, is that, you know, there's ways to be in the comment section. You know, we don't have to show each other up. Everybody's smart. I got a lot of smart guys in the comment section of my videos. I learn a lot of stuff. A lot of guys are posting good stuff, emailing me good information, you know, and I use it. I'm not an expert. I don't claim to be. I just happen to be good at what I do. And I have to be a very good writer. And there's a guy in the comment section of my last video, part 2. Oh, by the way, I was only joking around. Those last 2 videos were tongue-in-cheek. I was having a little bit of fun. Because I was making a point. Is that, yes, I know there are a lot of people that tune into like the first 3 or 4 minutes of my video. They're waiting to hear that magic thing. Keep waiting, guys. You're never going to get it. Because, as I said in the past, ADT, the burglary alarm company, they're never going to make a guarantee. I can't make a guarantee. We're dealing with people that break the law for a living. Okay? That whole child support thing is a fraud. Complete fraud. Remember I told you earlier in the video, it's a big production. A fake judge called Your Honor, a child support administrative process in a court building. Oh, I got to do a video on this too. a subscriber, Steve Willing from Illinois. He found this, one night searching on the internet. He has a breakdown on the legislative website, NCLA, I want to say. So they have all the legislation throughout the country, and it has a breakdown of all 50 states for child support. And it'll tell you in your state how they go about child support. If it's an administrative process, if it's a judicial process, or both. It's really good stuff, and it gives the state statute, and it's a good weapon. So then you know how to go at the child support order. Okay, so now off the top of my head, I can't think of a particular state that is strictly an administrative process. But if it's an administrative process, you can go about getting a dismissal administratively, okay? But again, here's the thing. It may be administrative, but they want you to think it's judicial. That's where the trickery comes in, okay? But then again, let's say it's a judicial. Now it says New York is a judicial. You want to know why it's a judicial? I just said it before. Every support order by a support magistrate needs what? A judicial signature. Also, it says that the the family court for child support is under the auspices of the judicial branch. That means that the judicial branch is overseeing it. They have to approve it. That means that every order has to be judicially reviewed. But you know the way they do it? They issue it. Remember I told you it's a Aeneas Prius court. So what they do is they issue the support order, and this is New York, and then you have to object. And then the objection goes before a judge. And then what the judge always does is dismiss it. But the support order stands without a judicial signature. See, they don't want to sign it, the judges. How do I know? Because the family court judge, in my case, refused to sign it. And I demanded her to sign it. I even cited the civil practice law rule that they're supposed to do it, and they wouldn't do it. Because they don't want to sign it, because they know that they legally can't. Okay? Because the judge can't have a pecuniary interest. They know it. So, anyway, I covered a lot in 20 minutes. 23 minutes. As we see, I didn't do a 6-minute video. All right? So, again, a substantive right is your life, liberty, and property that's protected in the Constitution. Okay? You got a statute. The courts are supposed to protect that. They're supposed to protect it under Article 6, Section 2, the Supremacy Clause. How many courts are actually doing that? But, I'm working on it. Remember I told you I go by feel. I found the quorum non judice. Then I found the Supreme Court case that states, the Supreme Court now, that says there has to be an injury in fact. It has to be caused by the respondent. It can't be a speculative injury. That's what family court is. How are they going to say you're paying not paying child support caused an injury? How? They can't. Can't be done. How are you going to... That means that somebody would have to have proof of an injury to that mother or that child because of your non-payment. How are they going to do that? They can't. I mean, I'm trying to have scenarios in my head. I don't know how. I guess, again, I said in my other video, their claim of the injury is being on welfare. But I see welfare as a remedy. I mean, I can articulate it that way anyway. All right, so obviously I'm not doing 6-minute videos anymore. It's 25 minutes in. I want to thank you guys. Enjoy the rest of your 4th of July weekend. Take it easy.